the land in survey number 1172B, measuring 2 acres 20 guntas, what was stated was half of that land was under cultivation. What was stated was that half of the said land was in cultivation. Therefore, the same would amount to 1 acre 10 guntas. However, the tribunal has considered 1 acre 24 guntas to be under cultivation and granted half of that land amounting to 32 guntas, which on the face of records he submits is not correct. And as such, this court ought to intercede and rectify the error committed by the land tribunal. Sri Lakshman Mandgani, learned counsel appearing for the respondent, would submit that the interpretation now sought to be given by the legal heirs of Siddhappa and Ningappa cannot be accepted. The said Ningappa, having given a statement on his own behalf and on behalf of
Shankar, who is the predeceased son of Siddhappa.
Shankar, the son of Siddhappa, that it is only 1 acre 24 guntas out of 2 acres 20 guntas which was under cultivation, and a statement having been made that it is only half of that land which was in possession of Ningappa and his family, 32 guntas, have been rightly granted by the tribunal. His further submission is that the said order having been passed on 20th April 1994, no action had been taken by the said Ningappa alleging to the contra. In fact, Ningappa had accepted the order passed by land tribunal in the year 1994, having not challenged the same until his death on 16/7/2007. It is only the legal heirs who have set up the above false claim.
Not Lingappa's legal heirs, my lord. Siddhappa's legal heirs.
Ningappanu
Even
idaralla.
Ningappa's legal is also there.
10 to 9 to 12.
Entire this one started because Ningappa's legal heirs tried to get their names entered in the record of rights. Then Siddhappa's children came
The
to know
interstate dispute is between yourself. You can't go to them.
that entries are being changed.
In
Because
reply-
then they questioned it because they are in position and cultivating.
Heard so and so peruse papers. Though a submission had been made on the earlier occasion that Ningappa could not have made a submission on behalf of Shankar, son of Siddhappa, since he had predeceased Siddhappa. And as on the date on which the statement is attributed to have been made by Ningappa, Shankar had expired.
In fact,
No-
his predeceased son Nantana had
No document has been placed on record to indicate the date of death of Shankar, to indicate that he had predeceased Siddhappa. Be that as it may, as rightly contended by Sri Lakshman Mandgani, the impugned order having been passed way back on 24/1994, and the said order having been acted by Ningappa during his lifetime. Furthermore, the same not having been challenged till his death on 16/7/2007, the above petition has been filed in the year 2011, challenging the order of 24/1994. This on the ground that Ningappa could not have made a statement as done on behalf of himself and on behalf of Shankar. And furthermore, that the statement made by him has been misinterpreted by a tribunal, inasmuch as what was required to be considered was half of the area of 2 acres 20 guntas and not half of 1 acre 24 guntas. This submission, this contention, not having been taken up during the lifetime of Ningappa having accepted 32 guntas granted by the tribunal and not having sought for 1 acre 10 guntas as now claimed, and the considered opinion that the legal heirs cannot travel beyond the order, and now claim that the statement made by Ningappa was to an extent of 1 acre 10 guntas. In that view of the matter, I do not find any grounds in the above petition. The land tribunal has rightly considered the land under cultivation to be 1 acre 24 guntas, land in possession of Ningappa and family being half of that, 32 guntas have been granted. No grounds being made out, the petition stands dismissed. List 3, serial number 5.
List 3, serial number 5. Vittal Teli.
Filed application for impleading. Permitted to take out a notice on respondent number 7. Fruits.
ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅವ್ರ ಮುಂಚೆ ಇಲ್ಲಿ
ಇಲ್ಲ 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 ಇಲ್ಲ
ಫಸ್ಟ್ ಟೈಮ್
ಫಸ್ಟ್ ಟೈಮ್
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್
notes both notes.
issue
I'll take out
notice
notes hand summons it will be kept on 6th or 7th I'll serve it.
issue emergent notice on IA 1 of 2025 returnable by 24th February. Petitioner is also permitted to take out hand summons on the proposed respondent number 7
I request
returnable by so and so.
Monday my lords by that time I'll serve and come since there is a now my lords I'm unable to harvest.
In the event of service being effected
Please.
prior to that date, the petitioner is permitted to move the court
Please.
for early consideration.
List 1, password matters. Number 11.
So objection is regarding my lords at page number 24 of the writ petition, my lords, sorry. Page number 17, there are certain marks, my lords, I undertake to comply it, my lords.
under the applicable law. With the above observation, the petition stands disposed.
40. Chetna Biraj. Chetna Biraj.
Ulial, Mr. Ulial. ಉಳಿಯಲ್ಲಿ ಯಾವ್ದು ಬರೋದು? ಒಂದಿನ ಬರ್ತಾರೆ, ಒಂದಿನ ಇಲ್ಲ. 2008 ಮ್ಯಾಟರ್ ಇದು. Any particular day he comes?
No.
Or any day he wants, any day he doesn't. ದಿನ ರಿಪೀಟ್ ಮಾಡ್ಬೇಕಿದೆ. Relist tomorrow.
Please.
43. FE Patil, Nandish Patil.
Lord, in this, there was a direction to secure the records.
ಬಂತ?
ಅಲ್ಲ, ಇನ್ನು ಭಾಳ I request to the Lordship that at least a day ನಮ್ಮ ಕಲಿಗೆ ಹೇಳಿದಾರೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಅದು.
And AG, already chairman of response shall be
ಅಲ್ಲ,
present ಅಂತಿದಲ್ಲ.
I have gone through the order, my lord, but ಅವರು whether it is communicated to them or not, my lord.
And AG seeks for one more week's time to secure the records.
2 days.
One communicate ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 1 week ಕೊಡ್ತಾರೆ.
Please.
We won't, but it has to come.
Yes, yes.
We don't want respondent number 2 to be present.
ಇಲ್ಲ, ಅದಕ್ಕೆ.
Records ಬಂದ್ರೆ ಮುಗೀತು. ಇಲ್ಲ 2010 matter ಎಷ್ಟು ದಿನ? Weeks time to secure the records. Relist on
Monday.
13th February. If by then the records are not secured, respondent number 2 shall be personally present.
Yes.
To this court.
46. SP Habballi.
Appearing for petitioners, my lord.
Yes, Mr. Shilwant.
M. Shilwan.
You ready, na? Though the counsel for the petitioner and respondent number 3A to G are present in person in the forenoon and the afternoon session, none appears for respondent number 8 and respondent number 8. If none were to appear for respondent number 8 on the next date of hearing, the matter would be taken up for consideration on the basis of submission of the counsels present. Relist on 11th February. Registry is directed to delete the name of Sri Pavan B. Dodatti as that appearing for respondent number 3.
My lord, his name be deleted because I have appeared on behalf of.
ಅದೇ ಪವನ್ ದೊಡ್ಡಟ್ಟಿ
Please.
ಡಿಲೀಟ್ ಮಾಡಿ.
Please.
ಅದಕ್ಕೆ ಬೆಳಗ್ಗೆ
ಹೌದು,
ಅದು
ಹೌದು.
ಕನ್ಫ್ಯೂಷನ್ ಆಗಿತ್ತಲ್ಲ.
ಹೌದು.
My lord, can I make one submission?
Yes.
The matter may be disposed extending the status quo, my lord. There is a partition suit pending in Banati till now.
Let him come if he doesn't come. If he doesn't come, we'll take it upon yourself.
53. Srinand Pachapure.
Matter, my lord. I have filed an application, my lord, for bringing the LRs on record, my lord. That's still pending. The petitioner number 1 had died, my lord. IA
53.1 disposal of the case bringing LR of petition number 1.
That has to be allowed.
Pleading proposed petition number 3. ಯಾರು petition number 3 ಯಾರದ್ರಲ್ಲಿ?
Lord, I have filed my objections to that. That is one of my sister, my lord, who has already filed a partition suit and which is ended up in a compromise. She wants to implead herself. So that, my lord, I have filed my objections also.
Mr. Kori Shettar. 53.1 during the pendency of the above matter, petition number 1 expired on
Lord, 8/7/2021.
8/7/2021, hence IA 1 of 21 had been filed on
23rd September 2021.
the said application being in time. Considering that the right to sue survives, IA 1 of 21 is allowed. The persons named therein are brought on record as P1A2,
B.
A and B.
A and B.
Counsel for the petitioner to carry out necessary amendment to the cost title and file amended cost title.
But in fact, my lord,
53.2, accepting reasons stated in support of IA 1 of 20 production so and so is dispensed. 53.3, a memo during pendency of the above matter, petition number 1 has expired. A memo has been filed to treat petition number 2 to 28 as legal representative of deceased petition number 1. The said memo is accepted. Petition number 2 to 28 are treated as legal representative of deceased petition number 1. Counsel for the petitioner to carry out necessary endorsement in the cause title. Yes, who is for the Shashank?
I'm
You
for
are here.
the similar matters.
Lord, next week.
Again, Natti.
Peanut is not. I have filed NOC Okalat, my lord. Shashank, Peanut name may be dealing.
Okay.
Deleted.
53 Ali Shri Shashank Hegde has filed R2 for current for respond number 2 and 3. Delete the name of Prakash Gowda in Natti as it appearing for R2 and 3. 53.2.
In the same.
3 Gakila.
Hakidin.
Very 2 Gakidira.
I filed, man. They have not shown me.
Shashank Hegde submit that he has filed Wakalat number for respond number 3 also. Registry to verify and print his name as such, if so filed, and delete the name of Shri Prakash Gowda and Natti as that appearing for respond number 3. 53.3. Registry direct delete the name of Shri P. Natti as that appearing for respond number 1. Yes.
Lord, next week, if it could be taken up, because I filed a memo, my lord, an IA, where, my lord, I'm not pressing some of the prayers, and my lord, it could be disposed of by a direction, my lord.
At the request of counsel for the petitioner, released on 13th February.
Please.
My lord, some other matters
Connect with
connected to
so-and-so.
some though.
In others, man.
54, 55, 56 urgent, 57, Mahantesh Patil.
For petition.
Records ಬಂದಿದೆಯಾ?
Records not received.
ಇಲ್ಲ, B group ಹೋಗಿದ್ದೆ records.
ಎಲ್ಲ records.
Records ಇಲ್ಲ. Like that.
Lord, in this case, my lord, they are seeking for quashing of the orders passed by the MA court. Miscellaneous appeal applications have been rejected. That orders have been questioned in the present writ petitions. So, my lord, records, district court.
Lord, I hope my friend has
ನಿಮ್ಮ ಹತ್ರ
produced
ಇಲ್ವಾ
my lord.
records ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲೇ ಯಾಕಂದ್ರೆ orders challenge is passed by the district court.
My friend has produced my lord in the connected matter, my lord. Memo joti ಹಾಕಿದೀವಿ some records are produced.
MA 75 of
ಹೌದು.
2014.
ಹೌದು. On IA number 1
I number
with regarding to delay.
Lord, in this matter, my lord, we have challenged only order passed in I number 6, my lord, delay application. Sorry.
ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಯಾವ ಮೆಮೋ ಡೇಟೆಡ್?
Please.
6/12/22 ಅಲ್ಲಿ ರೀಗ್ರಾಂಟ್ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? MA ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Pura entire record alla some records we have produced before honorable court, my lord. ನಮ್ಮ ಹತ್ರ ಇದ್ದಿದ್ದು records.
ಸಮ್ ಮೇಲೆ ಹೆಂಗ್ ಮಾಡೋದು?
Please.
Registry is directed to secure the records in MA number 75 of 2014, said to be pending on the file of the first additional district and session judge Belgavi, released on 24th February.
Please.
58 urgent, 59, Jagdish Patil. Jagdish Patil. Fifty-nine.
59. Arigni.
It's a mandamus.
Yes.
I'm for Shivlaj Badoli, sir,
Ah.
serial number 59.
Mandamus ಏನು objection ಏನು?
No, sir, senior is not available in town. So kindly be adjourned for 2 days, my lords.
Senior?
He's not available, my lords.
So,
Kindly be adjourned, my lords.
where is he gone?
He's in Bangalore, my lords.
They are seeking for implement of annexure A, my lord.
ಅಷ್ಟೇ, ಏನು ಇದಿಲ್ಲ.
Annexure A.
There is no need to give any adjournment.
Yes.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the order dated 23/12/1983 bearing number so and so passed by respondent number 1 at annexure A, and the order passed by this court dated 2/2/2022 in WP number 100359 of 2022 at annexure P have not been implemented. In that view of the matter, I pass the following order. Writ petition is allowed, a mandamus is issued, directing the respondents to implement the order dated 23/12/1983 passed by respondent number 1 at annexure A, as also the order dated 2/2/2022 passed in WP number 100359 of 2022 at wide annexure P within 30 days from the date of receipt of a copy of this order.
60 Naikwadi. Naikwadi.
Mr. Karvi,
Yes, sir. Venkatesh Kharvi.
Deputy Commissioner order challenge ಮಾಡಿ.
Yes, sir.
So Karvi ಅವ್ರು ಬೇಡ.
Annexure K.
ಎಲ್ಲಿ ಅವರು?
It is a rectified order.
ಅವರೇ ಅಲ್ಲ.
Yes.
Rectified order has been passed, that has been questioned. With regarding to only extent and survey numbers have been changed in the rectified order. That order is questioned before this honorable court.
Your Lordship,
Page
apart
37.
from that, this petitioner's father as well as the respondent number one's father, they have been allotted gift deed, wide annexure C, Your Lordship. And accordingly, the name of this, both the names were mutated as per annexure D. And thereafter, this Shivappa, the father of the respondent, he deleted the mutation entry. And accordingly, the matter was challenged before this AC. And AC has passed the order condoning the delay, as well as all the documents were produced before the AC wide annexure K order is passed in favor of this petitioner, and name of the petitioner were mutated in the record of rights. Meanwhile, during the Kuwait period, the children of Shuappa, present respondent, they filed the revision petition before the DC, and this impeached order came to be passed, and no opportunity was given to this present petitioner to produce document as their counsel was died during that particular point of time, Your Lordship. And all the documents which are part of record before the AC office were not produced and recalled before this DC. And DC has not properly perused the matter, and impeached order came to be passed. Whereas in annexure J order passed by the Assistant Commissioner, he has observed in length with regard to the document produced. Around 9 documents is produced in page number 35 at annexure J, Your Lordship, where some citation regarding delay condonation was also produced before the AC. And accordingly, after going through the entire record, during the pendency of the appeal before AC Assistant Commissioner, the Dyamanna died, and his present petitioner, they came on record, Your Lordship. And no documents were in custody of the deceased advocate, one Mr. Dodmani. He could not produce the same before DC. And some other counsel was engaged. Within a short span of 8 to 15 days, impeached order came to be passed. Whereas when we go through this order passed by the Assistant Commissioner, wherein entire documents were produced, delay condoned, and various reasons given by the has been same condoned by the AC.
Mr. Karvi.
Lord, order dated 2/9/2021. That is the original order which has to be challenged. Wherein, my lord, at page 39, operative portion, ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಾದ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಎದುರುದಾರ ದ್ಯಾಮಣ್ಣ ಅವರು ಮಕ್ಕಳಾದ ವಾರಸಾರ್ ಎಂಬುದಕ್ಕೆ ಯಾವುದೇ ಸೂಕ್ತವಾದ ದಾಖಲೆಯನ್ನು ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಎದುರುದಾರ ಶ್ರೀ ದ್ಯಾಮಣ್ಣ ಕರಿಗೌಡರ್ ಅವರ ವಾರಸುದಾರ ಆಗಲಿ ಅದನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಮೂಲಕ ಪ್ರಶ್ನಿತ ಜಮೀನಿನ ಹಕ್ಕು ಸಾಬೀತುಪಡಿಸಿಕೊಳ್ಳಲು ತಿಳಿಸಿ ಪ್ರಕರಣವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಲಾಗಿದೆ.
What document have you produced that you are the legal heirs?
Your lordship, one, any accommodation, short accommodation, you will clarify your lordship. Something has been missing, your lordship. I request one time, so clarify.
Petitioner seeks fund is granted 10 days time to produce any document evidencing the petitioner to be the legal heirs of late Damana. None appears for respondent number 1. If none were to appear for respondent number 1 on the next date of hearing, the matter would be taken up for consideration on the basis of submission of the counsel for the petitioner. We list on 18th
Yes, your
February.
lordship.
61, Girish Bhatt.
Senior counsel is held up with another court, my lord. Kindly you next week time.
Lord,
Next
this
Thursday.
in LAC proceedings, impleading application was filed. That is rejected by the trial court. Lord, if they have got any right in compensation, they have to invoke section 30. Rightly, it is rejected by the trial court.
Next week.
Go for reference under section 30.
Next Thursday, my.
The request of counsel for the petitioner. Learned counsel for respondent number 1 submits that the impleading application filed LSA proceedings has been rightly rejected by the said court since the remedy available is for seeking for reference under section 30 of the Land Acquisition Act 1894. Counsel for the petitioner seeks for a short accommodation to obtain instruction, make a submission. Relist on 11th February. It is made clear that no
Interim
further
order.
adjournment would be granted.
It is the interim order.
Order earlier granted is extended till next day.
62 urgent. 63, K. Raghavendra Rao.
SCST.
Relist on 19th March.
One submission, last two occasion, your lordship, I have not sought for any adjournment.
We are adjourning all SCST matters. Judgment agovargu we can't take up. Constitutional challenge is
Please.
pending.
Please.
54, Nirmala BG, NH Patil.
My lordship, it's a writ of certiorari as well as the rent of mandamus. It's a writ of certiorari as well as the mandamus, my lordship. My prayer is to set aside the annexure F that is passed by the respondent number 1, that is CMC Rane Banur, my lordship, and direct them to remove the unauthorized illegal construction in my, where I have the easement right, my lordship. Kindly see the page number 19, my lordship.
Yes.
That's annexure D. In the 2016, my lordship, I filed an IAS, I filed an, I made a representation to consider my representation to remove the unauthorized illegal construction, my lordship. But till 2022, they have not considered. Hence, I filed an writ petition, my
Where are
lordship.
the photographs?
Pardon, my lordship?
Photographs ಎಲ್ಲಿದೆ? Photographs produce ಮಾಡಿದ್ದೀರಾ?
No, my lordship, I have not produced any photographs.
Sketch ಅಲ್ಲಿ where is this illegal construction?
Photographs I have not produced.
2872A2B.
Kindly see the annexure G, F and H, my lordship. Annexure F, annexure G, H and J, my lordship. Where they occupied, my lordship.
Yes, Mr.
The respondent to himself admitted that, my lordship.
One.
I appear for respondent number
Have you
1.
granted any plan sanction?
My lords, as far as no, there are, my lords, in that property, one house, my lords, which is built up on 440 square feet. For that, my lords, they have taken permission. For the another building that they say, no permission is taken. My lords, in the endorsement, we have
And what are you
that.
doing?
But that is a building of some 50 years old.
50 years.
50 years old.
They
Now,
said
my lords, that is the endorsement. The dispute, my lords, they are all of the same family. The petitioner as well as, my lords, the respondent number 2.
ಅವ್ರ ಗಲಾಟೆಲ್ ನಿಮ್ಮನ್ನು ಕರೆಯೋಣ ಅಂತ.
Please, my lordship.
First,
But
my lords, they
respondent
say
to
there is
himself
a
admitted.
50-year-old building you
Allah,
can't.
my responsible to himself admitted they have not taken any permission to construct that house, my lordship.
50-year-old building, madam.
They said 50 year, my lordship, but
ನಿಮ್ ಕ್ಲೈಂಟ್ ಎಷ್ಟು ವರ್ಷದ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ?
Their intention is, I should sell the property, I should walk away. That is the harassment.
no, no.
That is what this honorable court earlier observed.
Went right, encroach ಮಾಡ್ಕೊಂಡು ಕಟ್ಟಿದ್ದಾರೆ, my lordship ಅವರು. Kindly see the annexure C, my lordship.
File a civil suit for that.
Ah.
Not ಇಲ್ಲ ಬರಲ್ಲ ಅದು.
That's what in the earlier occasion,
But
this
now the
Honorable Court
easement
has.
right, they are
Easement
not,
now kodakagala.
they already given, my lordship. Can you see the next C, my lordship? It's there, my lordship.
Annexure C.
Next page number 17.
Hmm.
They'll mention again, my lordship.
If there's any violation, you'll have to file a
ಈ
civil
ನಂಬರ್
suit.
ದಿಲ್ಲ ಮುಂದಿನ
Your allegation
ಖುಲ್ಲಾ
is that
ಜಾಗದಲ್ಲಿ
without taking permission from respondent number 1, they have put up construction. Submission of Mr. Osmani is that construction is 50-year-old. Question of, respondent number 1 was not even in existence at that time. So question of permission will not arise. So if it's a easement right, you go before the civil court.
My lordship, I'm not asking about the easement right. Easement already there, but my question is to construction, unauthorized construction it is.
ಅನ್ನತ್ರ ಇದೆಲ್ಲಿ ಬರುತ್ತೆ 50 ವರ್ಷದಿಂದ ಏನಿತ್ತು ಯಾವ ಪ್ಲಾನ್ ಇತ್ತು which is the plan to follow
That is true.
when they were not there in existence. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the second
Malaysia,
respondent
why-
has put up construction without obtaining permission from respondent number 1. Learned counsel for respondent number 1 submits that the construction being more than 50 years old and having been put up before respondent number 1 was constituted.
That Milords,
ಯಾವಾಗ CMC ರಾಣೆಬೆನ್ನೂರ್
Ranebennur Milords.
50 years ಬಂದಿದ್ರ
Because in the endorsement Milords, that's what we have said. 1970 or 75, construction is done. And we don't have any records pertaining to Milords.
In the year of 2050 and
You have given
and
that endorsement to them.
50 years ago, and respondent number 1 not having any records there too. And the consider opinion that it cannot be said that the construction is illegal or unauthorized. Insofar as the claim of the petitioner as regards easement or otherwise, it is for the petitioner to initiate such civil proceedings as may be advisable in accordance with law. Reserving such liberty, petition stands disposed.
In the earlier writ petition, this Honorable Court has already given that liberty earlier.
To the liberty.
Yes, yes. Now they will file a review in this writ petition now. Earlier review petitions, it is only to see that
Review ನಮ್ಮಂದೇನೆ ಬರುತ್ತೆ.
ಅದು I should sell the property, I should walk up the property. That is their intention.
ಒಂದ್ಸತಿ ಹಾಕಿದ್ರೆ ಕಾಸ್ಟ್
Earlier written review ಹಾಕಿ dismiss ಆಯ್ತು. Thereafter.
ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು ಹೇಳಿ ಅಷ್ಟೇ ಕಾಸ್ಟ್.
65, KL
Malaysia,
Patil.
Malaysia,
KL Patil.
ಸತೀಶ್ ಜಿ ಬಿರಾದರ್ ಅಲ್ಲ ನೀವು ಅಪೇರ್ ಆಗಿದ್ರಲ್ಲ ಶ್ರೀ ಪ್ರವೀಣ್ ಪಿ ತಾರಿಕರ್ has entered appearance for respondent number 429 registry is that delete the name of Shri Satish G Biradar as that appearing for K-Vector respondent number 4 to respond 9. Yes. Ready?
Please, ready.
ಹೇಳಿ.
In this, my lords, the vendor of the petitioner, my lords. As per the compromise decree passed in FDP number 15 of 1998, a portion of 7 guntas was allotted to Rukmini Bai and another 7 guntas was allotted to Sudha Bai, who are the vendors of the petitioner, my lords. Accordingly, my lords, they executed an agreement of sale on 27/2009 as per an annexure A, my lords. Then further, my lords, on 17/6/2010, as per annexure B, my lords, page number 30, they have sold the property by virtue of the registered sale deed. And my lords, then my lords, the petitioner herein has gifted this property to their son.
Registered agreement to sale ಆದ್ಮೇಲೆ
As per page number 30, sale deed has came to be executed by these both my lords.
ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ?
Sale deed agide. As annexure B, page number 30, my lords.
17/6/2010.
Please. Then my lords, the petitioner gifted these properties to respond number 6 and sorry, my lords, respond number 10 and 11 by virtue of a gift deed dated 29/2/2012 as per annexure C, my lords. Accordingly, the name of respond number 6 and 9 came to be mutated as per annexure
D, page number 50, ME number H17, my lords. Surprisingly, my lords, the legal heirs of the petitioner, the respond number, this Rukmini Bai, got mutated their name by virtue of MR number 40 of 2022, by virtue of an order passed in OS number 438 of 20, which is filed seeking permanent injunction restraining these purchasers interfering their position, my lords, which is an ex parte order. But there is no declaration was sought by the respondents, my lords. That mutation was challenged before the Assistant Commissioner as per Annex Sheriff, page number 54, my lords. My lords, the Assistant Commissioner, by virtue of order, my lords, as per Annex Sheriff H, page 69, my lords. Operative portion, my lords, page number 73.
Yes, Mr. Praveen, you are not challenged the sale deed.
I challenge it.
Where have you challenged?
I challenge it in OS number 265 of 2013. OS 265 of 2013.
The plaint ಎಲ್ಲಿದೆ?
Plaint, it is not there. No? Judgment is there, no?
Judgment ಇದೆಯಾ?
Judgment is there.
OS 265 of 2013.
265 of 2013, Lord, where it is
filed by Rukmini Bai and Sundara Bai.
Was page number 20, my lord, operative portion, internal page. Suit filed the petition. Plaintiff is hereby declared with cost. Defendants and other agents and servants and anybody claiming on behalf of the defendants are disturbing peaceful.
Possession ಅಷ್ಟೇ.
Please, the sale deed dated so and so declare as same and bogus of document.
He is declared a sham and bogus document.
Please.
It's an ex parte decree, my lords. We have challenged it in a miscellaneous, my lords. The miscellaneous is pending, my lords, now for consideration.
So now the decree will apply.
Because
you succeed there.
Allah, it's an ex parte order, my lord.
So what? Who asked you to be ex parte?
We placed ex parte, my lords, without notice.
Without notice, ಎಲ್ಲಪ್ಪ.
Notice ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ. Defendant placed ex parte. Jahida and Asim.
ನೀವು ಸರ್ವ್ ಆದ್ಮೇಲೆ ex parte ಅಂತ ಆಗಿದೆ. ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂತ.
Then we filed a miscellaneous pending for consideration, my lord.
Today there is a decree. Has this decree been stayed in the miscellaneous?
I have to seek instruction to that extent, my lord.
If it is not stayed, then the order of the DC is proper.
Please, my lord.
Learned counsel for the petitioner seeks and is granted a week's time to ascertain and make his submission if the decree, judgment decree,
OS number 265.
dated 17th March 2015, passed in OS number 265 of 2013 by the 5th additional civil judge in JMSC Belgavi, has been stayed in any proceedings.
It has been not statement. Miscellaneous order should I have produced, my lord?
Let him
Please.
be listed on 11th February.
Please.
Obligation.
P6, Prashant Usmani.
New petitioner.
Please.
ಮತ್ತೆ dismissal ಇದು.
Yes. Lords,
petitioner ಅಂದ್ರೆ dismissal.
Yes. Both cases. You know,
next one we'll have to see. But this one,
no, my lords, this here, my lords, he was absent for, my lords, from 1/8/2013 to 24/9/2013. More than, my lords, close to 9 months, my lords, he was absent, and he was a trainee. Articles of charge was issued, inquiry was conducted. Then, my lords, he was dismissed from service. He approached the labor court under KID. The KID, my lords, takes notice of the fact that the on merits, my lords, it says that he was unauthorizedly absent. And, my lords, the dismissal order is set aside. Reinstatement, continuity of service without back wages, my lords, is ordered. But may kindly see page number, my lords, 36. This is, my lords, page 34, my lords. This is the dismissal order. Page 36, my lords will find a tabular column at page 36. The first, my lords, case, this is the present case. In, my lords, 2013, when the inquiry was going on, my lords, he has committed, my lords, subsequent 3 cases. Another fact, my lords, this honorable court, my lords, are directed to reinstate him on my submission that we'll reinstate him, extract work, and then we will, my lords, pay him the regular salaries. On that interim order, he was reinstated. There again, my lords, he is involved in another pilferage case. And all this, my lords, during when he was a trainee, he was not yet absorbed. The trial court, the labor court, my lords, holds that he has given a medical certificate from for up to, my lords, 19/8/2013. That medical certificate, my lords, is issued by a private doctor, wherein, my lords, he is not even examined.
Exhibit P9.
Records ಬಂದಿದೆಯಾ?
For a moment, my lords, exhibit P9, which is the medical certificate. Sorry, it's exhibit R9. Exhibit R9.
P9.
You delete the evidence of this Dr. Sholapur?
Please, my lords.
Or evidence lead madidra?
He has led evidence before the labor court.
Of this doctor?
No, they have not. The author of this document is not examined.
Chronic malaria fever, severe anemia.
Yes.
Then chronic malaria fever andre artha ಏನು?
Plus his father was also not well. And
what is chronic malaria fever? You know, worth, you have to take action against this doctor.
My lord, he served for 3 years. He was not put on probation. He was appointed in.
ಇನ್ನು 10 ವರ್ಷ ಆದ್ರೇನು ಆಗಲ್ಲ. If he is absent without permission, without leave.
And during absenteeism period, he was transferred from Saunur to Hirekarur, and relieving order was not given. And he was kept out of duty. That was not informed to him.
Exhibit 10/1/2013 to 18/8/2013.
Yes, out of that.
You did not lead his evidence.
Only for 37 days, the labor court
has lead his evidence. You did not examine the doctor. There is no medical, except for this medical certificate, there is no other diagnosis certificate of malaria, nothing.
The thing is that he was transferred from Saunur to Hirekarur. He was not informed. And even the that is admitted by
that
the
is not the subject
reporter.
Matter of this petition today, Mr. Counsel. Today, the subject matter of this one is your medical certificate, which has been accepted by the trial, by the
labor.
tribunal. What we have to see is whether this could have been accepted. On the face of it, it cannot be accepted. Rest of the disputes are not subject matter of this petition.
Some alternative punishment and reinstatement, please be confirmed.
ಸುಳ್ಳು ಹೇಳಿದ್ರೆ there is no chance. ಸುಳ್ಳು ಹೇಳಂಗಿಲ್ಲ. Not like this.
But he was transferred.
He should have been dismissed then and there if he's involved himself in like this. ಸುಳ್ಳು ಏನಾದ್ರು ಸುಳ್ಳು ಹೇಳ್ಕೊಳ್ಬಹುದು ಅಂದ್ರೆ what is this chronic malarial fever? We will be directing action against this Dr. V.N. Sholapur. for having issued such a certificate. Petitioner Road Transport Corporation is before this court seeking for the following reliefs. The respondent was, though engaged as a trainee driver cum conductor, had remained absent from duty from 10/1/2013 to 24/9/2013 without submitting any leave application. Show cause notice having been issued, the reply not being satisfactory. A second show cause notice was, inquiry was held, second show cause notice was issued, inquiry being held against the respondent. Respondent was dismissed from service on 2/7/2016. It is challenging the same, that the respondent had approached the labor court seeking for setting aside the order dated 2/7/2016. In the claim petition filed, the respondent contended that he was suffering from severe typhoid and hepatitis on account of consumption of unhygienic food and water, and he had to look after his ailing father who was settled at Ilkal. It is further contended that he was transferred from one depot to another without any justifiable reason and without pre-intimation. And he was deliberately kept off duty. The further contention was that the inquiry officer has not conducted the inquiry in a proper manner, and as such the inquiry report also is required to be set aside. The tribunal, on evidence being led, came to a conclusion that the inquiry was proper and correct. However, accepting a medical certificate produced at Exhibit R9 issued by one Dr. V.N. Sholapur, operating a Sanjeevani Nursing Home Ungund, that the petitioner was under his treatment from 10/1/2013 to 18/8/2013, came to a conclusion that the absence of the petitioner was not unjustified since he was unwell during the said period, and as such came to a further conclusion that the absence being justified, the punishment of dismissal was not proper, and directed the petitioner to reinstate him into services to the original post with continuity of service and all other consequential benefits without any back wages. It is challenging said order that the petitioner is before this court. Shri Prashant Usmani, learned counsel appearing for the petitioner, would submit that even when the proceedings were pending before the labor court, the petitioner had been unauthorizedly absent. When the matter had come up before this court, in persons of the orders dated 9/8/2024, the workman was directed to approach the petitioner corporation. The petitioner having been, the workman having been reinstated, continued to remain.
No, it's not a case of absenteeism, it's a case of pilferage. In fact, a more serious.
Petitioner, the respondent workman, indulged in pilferage, as regards which separate inquiry has been initiated. On the basis of the above, Shri Prashant Usmani submits that the conduct on part of the workman does not inspire confidence in the Road Transport Corporation. The tribunal has not taken into account the documents in the proper perspective, has accepted the medical certificate without the doctor having been examined, which goes to the root of the matter, the medical certificate not having been established, the tribunal ought not to have passed the order of reinstatement. Per contrary,
ASR Namazi.
ASR
Namazi.
Namazi, learned counsel for the respondent workman, would submit that the medical certificate has been issued properly by the concerned doctor and has been properly accepted by the tribunal. No fault can be found with the tribunal accepting the said certificate. The workman having explained his absence from 10/1/2013 to 18/8/2013, the absence from work is only for a short, unexplained absence from work is only for a short period of time. And as such, the tribunal has rightly held that the punishment imposed is not proportionate with the allegations made against the respondent.
Transfer.
As such, it supports the order passed by the tribunal. Heard so-and-so perused papers. The only document which has been placed on record by the workman is a medical certificate dated 18/8/2013, issued by one Dr. V.N. Sholapur, who has stated that the petitioner is under treatment from 10/1/2013 to 18/8/2013 for chronic malaria fever and severe anemia, and that he will be able to return to work on 19/8/2013. The said doctor admittedly has not been examined by the workman, and apart from the certificate being produced, there is nothing else which has been placed on record to establish the so-called diagnosis of the said doctor, inasmuch as what has been stated in the certificate is chronic malaria fever, which would require a diagnostic test to be done to confirm that a person is suffering from malaria. That apart, the reason given by the workman initially for his absence was that he was suffering from typhoid and hepatitis due to consumption of unhygienic food and water. The reason given by the workman initially of typhoid and hepatitis compared with the reason given in the medical certificate of malaria is completely contradictory and only leads to a conclusion that the workman has given false reason for his absence. If this is taken into consideration with the fact that the concerned doctor has also not been examined, I am the considered opinion that the said certificate issued by Dr. V.N. Sholapur could not have been accepted by the trial court, by the tribunal, in justification of the absence of the workman. If the said medical certificate is eschewed, then the absence of the workman remains unexplained and without any justification. In that view of the matter, I am of the considered opinion that the tribunal failed to take into consideration the above aspects, and the order passed by the tribunal directing reinstatement of the petitioner into service is completely unjustified. As such, I pass the following order. Writ petition is allowed. A certiorari is issued. The order dated 23/9/23, passed by the Principal District and Session Judge Bagalkote in ID number so-and-so at Annexure A is set aside. The order dated 2/7/2016, dismissing the respondent workman from service is confirmed.
The connected matter appear for the respondent. This is also case of absenteeism. He was absent for.
But directly
Act easy agalla. Facts correct again. If facts are in his favor, we'll pass in his favor. Adu nodbiಟ್ಟು ಇದು ಹಂಗೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
Milord, it directly attracts the justice. The ruling,
he is also
it
a
is
trainee
covered
here.
by same ruling. The conclusion made by as the claimant was a trainee.
Mr. Namazi, let us see the facts.
Lords, he was appointed as a trainee conductor. Lords, in the year 2014. Lords, he remained absent. Request Lords to kindly see Lords the tabular column again, his past history. 2014, my lords, he was appointed. Page 59, that is the dismissal order, which starts at 55. His past history, my lords, can be found at 59.
Page?
59. There's a tabular column, my lords.
57 is
50, my lords, 55, my lords, is annexed D, that is his dismissal order passed by the disciplinary authority.
ಇಲ್ಲಪ್ಪ ಎಲ್ಲ ರಾಂಗ್ ಇದೆ ಇಲ್ಲಿಂದ ಅಷ್ಟು ಪೇಜ್ ಮಿಸ್ಸಿಂಗ್ ಆಗೋಯ್ತು ಅನೆಕ್ಷ ಡಿ ಇಸ್ 42 13
My lords, it's dated 29/7/2016, my lords.
Where did the 13 pages go? 42 ಇದೆ ಇಲ್ಲಿ.
The copy that is served upon me, my lords, sir.
13 pages ಎಲ್ಲಿ ಮಿಸ್ ಆಯ್ತು? What do you have extra there?
The tabular column, lords, gives his past history. 2014, he was appointed as a trainee conductor.
Claim petition has been dismissed.
Yes, please,
on
my
the
lords.
only ground that is a trainee worker.
No,
Yes.
my lords, may kindly see, my lords, para 20, my lords, of the labor court's order.
That has not been appreciated.
No, the court holds that his authorization, his absence from the duty, my lords, was not supported by any evidence. Page 20, my lords, may I read? It also takes, my lords, the fact that he is a trainee conductor, and therefore, my lords, that is also, my lords, one of the reasons. But para 20, my lords, where the court discusses on merits.
ಇಲ್ಲ ಏನು ಫೈಂಡಿಂಗ್ ಇಲ್ಲ ಅಷ್ಟೇ ಒಂದು ವೇಗ್ ಫೈಂಡಿಂಗ್
The medical
no any
certificate.
medical investigation ill health of claimant's mother ಅಂತಾರೆ ಇವ್ರದ್ದೇನು ಇಲ್ಲ.
He says, my lords, he is absent. He remained absent because of his ill health as well as, my lords, his mother's ill health.
2.5 months.
Again, my lords, the medical certificate.
Only references to this. We'll remit the matter to the tribunal to consider it.
That can be done.
Because there are allegations made. Petitioner is before this court seeking for the following relief. The submission of Shri A.S.R. Namazi, learned counsel for the petitioner, is that the labor court has dismissed the claim petition filed by the workman only on the ground that the workman is a trainee driver cum conductor. He relies upon the decision of a coordinate bench of this court. In dated 24th April 2024, in WP number 100878 of 2017, to contend that there is no post of trainee driver cum conductor, and as such, the reliance placed by the labor court on the decisions of the division bench of this court in WA number 2596 of 2005, WA number 100369 of 2014, and WA number 100383 of 2014 is not proper. On this ground, he submits that the above petition is required to be allowed. Shri Prashant Osmani, learned counsel for the petitioner, submits that it is not only on the ground of the workman being appointed as a trainee driver cum conductor but also on the ground of unauthorized absence, that the respondent workman has been dismissed. Heard so and so produce papers. ಅಲ್ಲಿ ಬೆಂಟೂರ್ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್, ಬೆಂಟೂರ್ ಅಂಡ್ ರವಿ ಸೇಮ್ ಮಾಡ್ಬಿಟ್ಟು. In that view of the matter, the labor court could not have dismissed the claim petition on the ground that the workman was a trainee driver cum conductor. However, in the present case, there are serious allegations made as regards the unauthorized absence of the workman, which aspects have not been considered by the labor court. In that view of the matter, I pass the following order. Writ petition is partly allowed. The order dated 23/12/2017 passed and so on so at Annexure A is set aside. Matter is remitted to the Labor Court Hubballi for fresh consideration in terms of the judgment dated 25th April 24 in WP number 100878 of 2017 and other connected matters.
Serial number 68, your lordship. And have any date, your lordship. Serial number 68.
Any date ಕೊಡ್ತಾರೆ?
No, your lordship. Day after tomorrow or Monday, your lordship.
ಅವೆರಡೇ ಡೇಟ್ ಅವೆರಡು ಆಗಲ್ಲ. Yes.
Any date, your lordship.
69 interim.
ಡೇಟ್ ನೋಡ್ಕೊಂಡು ಕೊಡ್ತಾರೆ. ನೋಡ್ಕೊಂಡು ಕೊಡ್ತಾರೆ.
Please.
Serial number 70, Malad, the direct the ADLR to survey the land.
Dismissal ಮಾಡ್ಬೇಕಾ? Withdrawn?
ಅಲ್ಲ, survey the land and submit report, Malad. Report not at.
Survey report. 70. Learned AGA seeks for a week's time to ascertain and make available survey report released on 13th February.
Your Lordship, list to serial number 28. It's a simple matter that clubbing IA has been dismissed. They have charged
Everything
that.
is simple until it is taken up.
Sure,
Everything is complicated until it is taken up. Everything can be disposed, but time ಆಗ್ಬೇಕು.
Please.
ಏನು ಸರ್?
Any specific date?
All the second list matter, wherever interim order is there, it will be.
Interim order will be extended, dates will be.
Please.
Which itself is a stay matter.
Date.
ಇವೆಲ್ಲ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ ಮಾಡಿರೋದು. ತಗೊಳ್ಳೋಣ ಅಂದ್ರೆ ಆಗ್ತಾ ಇಲ್ಲ ಅದು. ಈ ಲಿಸ್ಟೇ ಮುಗಿತಾ ಇಲ್ಲ.
Lordship, any date may be fixed, your lordship. Serial number 68.
Or any date, 2026 January 10th.
Sir, list number 2. ಅಲ್ಲಲ್ಲ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಕೊಡ್ರಿ. ಅಲ್ಲ ಫಸ್ಟ್ ಅಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಕೊಡ್ರಿ. ಅಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹಾಕಿ. ರೀಚ್ ಆಗಲ್ಲ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹಾಕಿ. ನೀವು ಮಾರ್ಕ್ಸ್ಗೆ ಕೊಡಿ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹಾಕಿ ಅಂತಾರೆ.
Monday. Monday 10th.
Sir.
14. ಅಲ್ಲ 10th please. 10th ಕೊಡ್ರಿ ಅಂತ. 13th 10 ಇರಲಿ. ಆಮೇಲೆ 73 ಒಂದು 73 ಒಂದು MBA ರಿಮೆಂಟ್ 73 ಅದು ಒಂದು 10.
ಸರ್ ಎಲ್ಲದೂ 10 ಕೊಡಲ್ಲ.
ಪ್ಲೀಸ್
ಮತ್ತೆ ಯಾಕಂದ್ರೆ
ಓಕೆ
ಲಿಸ್ಟ್ ನಂಬರ್ ಎಲ್ಲ ಇಂಟ್ರಿ ಆಗುತ್ತೆ, ಎಲ್ಲ ಮಾರ್ಕ್ಸ್
ಸರ್, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಬಂದಿತ್ತು.